activities
so
there.
help me, Mr. Gannon, try to figure out what the harm is to the federal government.
Yeah.
In Bagram, take the contractor that doesn't properly cook the chicken. Take the contractor that doesn't properly maintain the trucks. Take the contractor that does a whole series of things that are going to injure or kill soldiers in violation of what the government has said is its policies. You know, the government has a policy manual. Here's how to maintain the trucks. Here's how to cook the chicken. And the contractor has operated in violation of that.
Yep.
Why it is that state liability would be so injurious to the government's interests in that context, which is, I thought, the context that we're concerned about in this very case.
That's right. And obviously we want our contractors to obey their contracts. We want them to obey military orders. But that doesn't mean that we aren't threatened by the imposition of the specter of tort regulation in the relationship between the military and its contractors, whether or not the contract has been complied with. As has already been mentioned, that's first of all going to lead to disputes about whether it's been complied with, that are going to be adjudicated half a world away, maybe with the government in an empty chair. But even when the state thinks it is trying to help the federal government enforce its own standards, this court has recognized that the imposition of state law can be a threat.
But tell me why.
Because it changes the relationship between the parties. It alters the behavior of the contractors on the ground. They're less willing to do risky things. They may indulge in a mother may I dynamic where they have to keep asking for permission. Hey, you want me to do something pretty dangerous? Can you please confirm for me, sign in triplicate that you have to do it this way? I want you to be aware that that's really dangerous because I want it on the record for some jury down the road.
Wouldn't that answer apply just as well to Boyle?
It would apply just as well to Boyle. Part of the difference, though, is that Boyle was talking about general procurement activities for the government writ whole. It happened to arise in the context of a military contract. The court's rule is not limited to military contracts. The hypothetical about the air conditioner is not about contracts.
But then what you're saying is that Boyle didn't really know what it was doing. It had a general contracting principle that would have been fine, and what it really should have done is to say, but this is the military, it's different.
No, I'm saying that because it was forming a general rule that happened to apply to a military context that did not involve combatant activity, it was undisputed that a helicopter that goes down 1.5 miles off the shore of Virginia in a training operation in the 1980s is not combatant activities, even though the helicopter was manufactured during the Vietnam War.
The arguments you were saying to me about how the government needs to be in control of its relationship with its contractors applies just as well to manufacturers of helicopters.
It does, but it's more important in the combatant, when the government is engaged in combat in a foreign theater of operations, that the type of distrust, the finger pointing, the threat that even though we're supposed to be fighting a war, we're supposed to be worried about how to protect security at Bagram. People are worried about making record for a tort trial that could be happening in one of 50 different states.
Thank you.
And so we do think that that's a threat, and the reason why it is different in Boyle, and Boyle requires there to be a violation because it is considering a different exception in the FTCA.
Thank you.
So,
Justice Thomas.